Welcome, folks. This is, again, the Joint Legislative Justice Oversight Committee, and this is June 3rd. And we're now going to shift gears and get an update from DOC as well as an update on our Justice Reinvestment 2. As many of you know, we've been working with the Justice Center within the Council of State Governments for a couple of years here in initiatives to implement within our Justice Reinvestment 2. And we thought this would be a good time to have a check-in, see how that's going and what progress we've made and where we hope to go in the next year. So I would presume turning it over to you, Commissioner Baker, Interim Commissioner Baker, to give us an introduction. And then we know we have other folks from DOC with us, as well as Dave Demure from the Council of State Governments, if we have questions directly for the Justice Center. So welcome, Commissioner.
Thank you, Representative Edmonds. I appreciate that. For the record, my name is Jim Baker. I am the Interim Commissioner of Corrections. And if it's okay with the committee, the way I thought we could present the information to you is I'll make a couple opening comments about where I see us with Justice Reinvestment 2. And then Monica is going to do a PowerPoint presentation for you, kind of walk you through where we are. Mm-hmm. Matt D'Agostino is here, can talk about some of the expenditures we've made and what we plan on doing with funds that have been saved that we're going to reinvest. And then certainly at any point we can answer questions. So I think for me, just a few comments to open up. I from where I sit since January of 2020, let's take out the fact that we've dealt with this pandemic, the largest pandemic that many of us have seen in our lifetime. I'm witnessing from where I sit what I believe is a real cultural shift in corrections to a community corrections model that really is based upon supportive thinking and not punitive thinking. And that work is ongoing. I'm certainly not saying we're there, but through such things as the training we're putting staff through around, as an example, around motivational interviewing, we're starting to move that shift towards not an organization in the field that's looking to catch someone doing something wrong, but to a point where we're rounding up and embracing partners to really be supportive of folks in the field. And Monica will touch on some of the work we're doing, and then I can circle back for more details from where I sit. But I want to point out one particular thing that I think is a major shift. Monica will touch on it in her slide, and I think when you come back to me for questions, I'll be more than happy to talk about it in more detail. There's an unbelievable amount of work being done inside AHS right now, really under the leadership of Deputy Secretary Jenny Samuelson. And we've been meeting on a regular basis with all the commissioners and other significant players in each department, looking at how we're going to blend together the existing Vermont Critical Care Initiative, which is, as you all know, is basically focused on healthcare, and a critical care model that we are designing and putting together that we're going to pilot into it in at least one probation and parole office. This is really a spin-off of you've heard me talk about what I think challenges are around entry into the system. Somebody on probation comes into the system. Someone comes out of a facility, transitions back into a community, where those challenges are for us. This is really focused on the population. This critical care model that we're working on is really focused on the population that really challenges the system. Mm-hmm. May not be the most serious crimes, and it may not be people with the highest risk to reoffend, but it's the people that burn staff out and burn other resources out that we're looking to focus on this chronic care model that's really going to be fashioned after what happens with Vermont's critical care initiative and wrapping services around. And we've actually had at least one case that I'm familiar with in Chittenden County with a young lady that was released from Chittenden. And I must say that's where I am today. I feel like I've been furloughed myself. This is only my second trip out, so I want to make sure I don't commit any technical violations with the committee today and have my furlough interrupted and sent back to my office in Arlington. But to finish this point, we had a young lady that was being released here that was a real challenge, and I'll just leave it at that, around developmentally issues. And for the first time, staff reported back to me, and advocates were calling me and telling me they've never seen the wraparound services to try to meet this individual's needs. And it took a lot of work. And so that's where we're headed. And I see us moving in that direction. I know it's a little slower than some folks would like to see, but we are turning, in some ways, turning the Titanic. And you don't do that on a dime. And so those are my opening comments, Madam Chair. And I'm gonna turn it over to Monica Weaver now, and Monica will give you a presentation, PowerPoint, and then to Matt D'Agostino, and then I'll come back to answer any questions.
Great, thank you, Commissioner. So Monica, it's all yours. And I know we do have this document that was posted to our web page, our committee page. I don't know if folks want to access that through their web page, or if you want to share it on the screen, Monica, we can go either way.
Certainly up to the committee. I'm prepared. I believe Peggy has given me permission to share my screen. I do have the presentation up.
Why don't you share your screen?
Okay, that's great. I will do that. And
you keep,
for the record,
Monica, you keep cutting in and out, so something's going on with your mic.
I can hear you. Can you hear me?
A little, yeah, I can.
Okay, that was was that a little too much? This is the better microphone.
Down a little bit.
I switched to the better microphone. So.
Okay.
All right.
Thank you.
Now I'll share my screen.
Okay. And identify yourself for the record as well. Yes.
Hi, I'm Monica Weber. I'm the Administrative Services Director for the Vermont Department of Corrections, and I appreciate the Commissioner giving me all of the power here, but I will be joined in this presentation by Dale Crook, who is also on the call. Dale and I are going to tag team presenting the information to all of you. So first, I just wanted to know, can you see the screen okay?
Yes.
The presentation? Okay. Fabulous. So what Dale and I decided we would do is just do an overview of justice reinvestment. Some of this will be a repeat for many of you, but I know there are some new members on the committee, and so we thought it would be helpful to kind of say what joint justice reinvestment is and what the Department of Corrections has been doing, and then move into some of the more future-oriented efforts that we have ongoing. Does that sound like a good way to start, Representative? Yes, yeah. Okay. So just as a really short overview, Justice Reinvestment, as has already been mentioned, what is an effort supported by the Council of State Governments Justice Center. And we started phase 2 of Justice Reinvestment in the middle of 2019. It is a data-driven effort to look at criminal justice systems, reduce recidivism, increase public safety, and reinvest funding into different services and programs. So there were several goals around some of the strategies that were adopted in Act 148 of 2020. And the three main goals that were adopted or addressed, at least for the Department of Corrections specifically, were to decrease returns to prison for people on community supervision, specifically those returns related to technical violations, as the Commissioner alluded to in his little joke there, and then to increase consistency in the use of sanctions across the department, and to increase the use of parole as a supervision strategy. Lots of nuance in there, but those are the three main things that we were working on with Act 148. Act 148 went into effect on January 1st of 2021, and we had to really dive into very specific strategies. And Dale's going to take over and sort of walk us through all of the different strategies that we have adopted and implemented. So he's going to start with this slide. So I'm going to turn it over to you, Dale, to introduce yourself and talk about what we're doing.
All right, thanks, Monica. For the record, Dale Crook, I am the Director of Field Services for the Vermont Department of Corrections. So really, when we're looking at the strategies to accomplish the goals of Justice for Investment, there are really kind of two areas. There's, I call kind of the micro, which was what was specifically asked from the department to implement things such as create community supervision furlough. Then there's also this more macro level where we're looking at the philosophical and departmental strategies on how we're going to embrace justice reinvestment. So some of the strategies that we looked at to accomplish the goals was first the creation of community supervision furlough, at the same time reducing other furlough statuses that the department has. So we rescinded conditional reentry, reintegration furlough, and home confinement. One of the concerns that was brought forth by CSG was that we had this very complicated system, and this accomplishment really kind of reduced some of the furlough statuses, and really some of the ones that really bogged down our system to a degree. Reintegration furlough, while it sounded good on the surface, where someone could be released 6 months prior to their minimum sentence, in reality, it kind of backfired as a lot of sentences were extended and a lot more time is added so individuals could do programming. So it kind of didn't have the effect that we wanted to. In addition, it was a huge administrative burden for staff. So actually eliminating some of the furlough statuses and being allowed to create a new furlough status of community supervision furlough allowed the department really to shift more toward a legal status that was more flexible and community oriented. Understand that furlough by definition is really an incarcerative sentence. So you're still technically in jail, but you're serving that time out in the community. Another thing that we did is we looked at all of our contact standards. And this is kind of one of the more philosophical approaches that we use to accomplish those goals. And we really revised them based on risk as opposed to legal statuses. So our department is really trying to adopt the evidence around supervision, and that the higher risk offender receives more effort and resources to address the offender and work with the offender and support the offender. That is regardless of legal status. So we can have high risk probationers will now get as much contact and effort put into supervision as a high risk furloughee. So that was one of the changes that we made, that there's not a difference between the legal statuses between furlough, probation, and parole, the big three statuses that we supervise. Another thing that we did is we revised all of our conditions of supervision for furlough. We had a lot of conditions, and a lot of times we were probably over supervising. So we kind of sat back and had a look at our conditions of supervision, because we created the new furlough of community supervision furlough. We really wanted to make it more of a community-oriented legal status. And in doing so, we really looked at our statuses, or our conditions. In addition, we also made it so we put a logic or understanding of when we add special conditions, kind of what was the primer or the conditions needed to add those conditions. So in essence, we were also reduced the number of conditions that we had. And then our special conditions of supervision, they had to be really connected to risk or behavior. So our population now on our community supervision furlough is supervised with a lot less conditions, trying to follow the evidence that over supervision gives poorer outcomes. And our conditions should be focused on the risks needed to manage the case. On the next slide, in part of doing that with our conditions, we also looked at the housing requirements. Under conditional reentry and the other furlough statuses, we had to have approved residents for furloughs to come out. Looking at with community supervision furlough and the changing of the conditions of supervision, approved residence is only needed for a select population now, where it's mindful. And I see Senator Sears has his hand up for a question.
Go ahead.
Do you mind if I ask questions now, Madam Chair, or should I wait?
Go ahead. Go ahead.
I guess my questions are about both the previous slide regarding low-level probation violations and the housing. And if we're, what's low level in one person's eye might be different in another, but in the housing and the change, the shift from congregate housing to supervised apartments or whatever you're going to call them. Could you be a little more specific about how that's related to both the community supervision and I want to make sure I understand. We're not talking about violations of conditions or requirements. We're talking, what are we talking about, or what's not going to be reported?
So this is not related to transitional housing or the changes in our transitional housing. This is around the conditions of supervision. And historically on conditional reentry, an offender had to have an approved residence that had a bunch of set of criteria to approve that residence. Under community supervision furlough, we have altered that to having an approved residence is only based on risk or a specific need. For example, a sex offender would not be allowed to live with certain populations. It's really based on higher risk offenders will be more likely to need an approved residence. The condition has changed so that now it's more of if you have to have a residence, but it doesn't have to be approved. And we do have the ability to say that you can't live at certain places. So it's almost, for an example, with the sex offender, you can't live near a school, but any other residence that meets certain criteria would be approvable. So
Okay.
that's one way that we looked at. So this is.
Thank
this
you. I
is based on-
misunderstood. At some point, I'd like to talk about the shift from congregate housing to
Absolutely.
whether that's actually a part of justice reinvestment or is a different issue.
Absolutely. We'd be more than happy to discuss that. And I know the commissioner would like to discuss that as well. So I will just continue right now, and I think we'll have questions for that in a minute we need. Well, one thing, continuing, 808F was repealed around unauthorized housing. This was a very confusing piece of legislation that really didn't, when we looked at the data as applying this, the offenders that fell under the 808 housing releases had a much higher reoffense rate than the ones that we had under conditions for housing separately. So that was repealed as one of the recommendations from the department that CSG recommended up to have repealed. One thing we did is we looked at driving. Historically, driving has progressed over time on furlough to we're not allowed to drive, to very limited driving. And now the department's view under community supervision furlough is if you have a legal driver's license, you're allowed to drive unless there's a risk to the public. Our stance is that there's an entire different department that regulates driving. And our job is to regulate risk of an offender. So if that driving does not involve risk of the offender, being in a rural state, driving is almost a necessity in order to be successful under supervision and just in life in general. We require our offenders to have supervision contracts and case plans. We've altered this and changed it to make it more effective and make more sense. We used to kind of force upon probationers this really in-depth case plan, and we didn't really have any authority to enforce it because in essence, the case plan is driven by the conditions of probation. We will talk about, I think, Act 14, but H20 is a pilot project, and this really will tie in very nicely to that about having supervision plans that are based on conditions of supervision, and those conditions of supervisions need to be addressed the offender's risk to reoffend and criminogenic needs. Another strategy that we used is we expanded the use of telephone reporting for our low-risk offenders. So we have two kind of big buckets in community supervision. We have one is called risk management, and these are the cases that we were most concerned with. They're higher risk, more violent sex offenders. We apply more of a resource and effort into supervising those cases. On the lower end, we call it administrative supervision, and we use telephone monitoring to help monitor these individuals. It's been a very successful tool that we've used over years. We've expanded it. We have great outcomes with it. And our call-in rate, which is surprising to me, is in the high 90 percentile rating. By using telephone monitoring and supervision, offenders don't have to miss work to come in. If there's transportation issues, if they're out in outlying areas, there's no concern for them coming in. We can monitor them just as effectively with telephone supervision and get just as good, if not better, outcomes based on that. So moving on to strategies to accomplish the goals of violations and sanctions. So that goal is really to reduce use of incarceration for behaviors that we can manage in the community and that does not pose a risk to victim or public safety. So some of the strategies that we did with that is all of our short-term sanctions we eliminated. We used to have sanctions that would allow shorter stays. It kind of looked like the Hope model on some people may understand that. There's not much evidence that it worked one way or the other. But what we do know is that these short interruptions disrupted offenders' lives and disrupted whatever stable factors that an individual may have in their life. By a short stay in jail will disrupt that. So we eliminated all of our interrupt sanctions for graduated sanctions. We created a standard to meet the Act 148 for return for incarceration, the Rule 74. We've had to add resources and staff time. It is a laborious and an administrative burden for the department, but we have been able to set up a process, and we're managing that process right now. As far as I know, while there have been challenges, we have not had really any cases that we've been called before as far as Rule 74 for how we're applying our interrupts and our revocations for supervision. So one bit of information I can let you know, we've had roughly 123 returns to incarcerations since January 1 of this year. and over half of those have been based on new offenses. The majority of the ones that are not based on new crimes have been really focused around absconding and escaping from supervision. So we have really dramatically decreased the technical violations going into our facilities. There's every technical violation that we incarcerate someone for more than 90 days, we have to notify prisoners' rights, and prisoners' rights is notified. And I do not believe that they have filed a motion to challenge any of our hearings yet. Moving on, so in adopting the Rule 74 and adopting our new violation strategies, there are really kind of two buckets of violations. One is a technical violation. We've expanded it a little bit than what is in the statute. So really a technical violation is any behavior that's not a new offense. We've limited it, technical violations on our site to new offenses that are violent, listed, or felony charges. So low-level misdemeanor charges, we're not considering that in our process as a technical violation. We will allow someone on furlough to continue as long as it's not, putting individuals at harm. On the risk level side, these are the behaviors that we are most concerned with because it does have an impact on public safety. So the risk level violations are violations of conditions of supervision where there is a direct public safety risk. It has to be direct. It can't be, if someone drinks and they have a DUI, they could be a possible risk to the public sometime. It is a direct linkage that the behavior could or has caused harm to the community or an offender. An offender-specific criminogenic risks will be taken into account when we're determining the level of risk to the public in our response. Higher risk offenders will have a more swift and immediate response because they do pose more of a risk to the public. Violent offenders that have repeated violence or sex offenders that have repeated sexual offenses, we will respond much quicker to those behaviors than someone that's lower risk on for a nonviolent charge. So we kind of adjust the risk to the public on how we respond. We've kind of broken down our technical levels into 4 different categories, and they're really kind of progressing up as they go on. So our lowest level is really around communication, having individuals understand what they've done, and as we move up the chain to level 2, level 3, and level 4, the restrictions and the requirements get more intense. The level 4 sanctions is our highest level of community sanctions that we have in the community because we don't incarcerate anymore. And that will usually involve more restrictive behaviors, referrals to other services that may need to help manage the offender's risk. And I see Representative Shaw. I don't know if Representative Evans wants me to call on the hands or not, or if that's your
I'm
job.
sorry, I was looking down. I'm sorry. Butch, go ahead.
Thank you, Madam Chair. So Dale, you threw out an intriguing figure in the previous slide when you're talking about violations.
Yeah.
You said, I believe I heard you say you had 123 furlough returns. Some in the first 6 months of the year. To some, that may seem like a lot. So I have no reference point. Is it 123 out of 130, or is it 123 over 500? I think you're trying to demonstrate a method of success here, but I don't have anything to look at it beyond that compared to.
Okay, so I don't have the numbers that we had back when CSG was analyzing all the information. So we do case staffings for all incarcerative interrupts now. And we've had 123 interrupt staffings so far this year from January 1. Of those, I believe 57 were for new offenses. These are hand count, so it's hard to really parse it out more than that. The ones that were not based on new criminal charges, the vast majority of those involved absconding or escaping from community supervision. Before, we had a lot of admissions into our facilities with short sanctions. We would have multiple sanctions before we get to longer interrupts. And one of the goals was really to eliminate the admissions into our facilities. What I could do, Representative Butch, is Representative Shaw, is I could go back and look at the PowerPoint from CSG from last year. I think that had a lot of the data in it as far as our interrupts, as far as a comparison.
Well,
Can I also add, Dale, just to add there is a very significant data monitoring component to Justice Reinvestment 2 implementation, and my team's been working very closely with the Research Center at CSG to finalize the data monitoring plan. And so we'll have, and I believe that they're going to share a little bit of that with the working group next week. So some of these numbers are going to be a little bit more clear as to what we're doing and how it's changed over time. But because we're just starting it, it's a little bit more challenging for us to be able to do that. But I just wanted to add in that there's a whole bunch of data that will be coming your way over the course of the implementation.
so thank you, Monica, for that, because there's no sense of Dale doing a whole lot of extra work if you're already doing the work that we'll be able to see at a future meeting. I want to make sure we're accomplishing the goals of JR2 to stop the revolving door of people being returned for technical violations. And I think it's from the tone that I got from Dale's comment was it's starting to work. So
Correct, sir. In my opinion, I think that revolving situation that we've experienced historically with furlough, we've kind of put an end to that to a degree. Doesn't mean we still have people going back and we still have sanctions that we're resolving, but as much the flow in and out of our facilities that way has decreased dramatically.
That's great. Thank you, Dale. Thank you, Madam Chair.
And as a follow-up on that, in comparison, because of the pandemic, and we've decreased the number of folks who are incarcerated, and I'm assuming a lot of folks then went on furlough status, do we have more folks now on furlough status than we've had in the past because of the pandemic?
Actually, no. This is kind of interesting. We are under 600 furlough cases, 550. I don't remember the exact numbers. We used to hover around 800 to 1,000, and our parole numbers usually match that. But recently, our community supervision numbers have dropped. As you can imagine, the courts aren't really going at full speed. One of the this is not going to sound, one of the benefits of COVID and how we applied supervision is that we kind of applied these strategies early on with COVID that we've implemented with kind of justice reinvestment because we kind of needed to. So really the transition from last year to January 1 and moving forward, it was not very dramatic for the staff because we were kind of forced based on the pandemic to kind of alter how we looked at behaviors. So in some ways it was a very short force change, and that we just adopted it and tweaked it over time to make what we've implemented now under the JRI more seamless for our population and for our supervision.
I have a question about absconding.
Dick?
Dale, the commissioner's warrant for absconding, what does that take to be absconding? I mean, can you be a little more specific about at what point you decide that the person does it mean that they have no intention of returning to the housing or whatever program or whatever, or does it mean that they are not in a place where they're supposed to be?
So for absconding, and we have it, there is some risk-based or community public safety exemptions to a degree. But after a period of time, if we are unable to locate an offender and the offender is avoiding our supervision and not reporting, and we're not able to supervise them, we consider that absconding. For our listed population, the most serious and most violent, it's roughly 3 days, 72 hours before we will look to do an ROM, which is the return on mint. And we'll start the commissioner's process later after that. For someone that is a non-listed, non-violent offender, we give them 7 days before we start going down the absconding process.
It's not somebody missing work on
No,
Friday.
we've never done it. We've always had that type of policy in place for a long time. There have been changes around the escape component that kind of goes with the abscond. It used to be once someone was absconded, it was actually an escape from community supervision.
Right. I remember changing that law.
And that was a new felony. Then it was removed for a year, and then it was added back on if there's I think the language is if they're actively trying to avoid supervision or fleeing the state, then it could become a new charge, and that's determined by the state's attorneys.
That's helpful. Thank you.
Okay.
Gail, do you want to do this slide, or do you want to move ahead and talk about?
No, I think we can move. That's pretty self-explanatory.
Yeah.
So risk level sanctions, are we on that one? I don't know which one. Go back one. So risk level sanctions, I just want to touch on this. One thing that we did as we're trying to adjust all of our sanctioning to be more consistent and to be more equitable across the system is we created this new term, significant violation. And the significant violation is kind of the threshold that we need in order to look to lodge someone in our facilities. And here's the definition of what a significant violation is. It's an arrest or a citation for a new felony or illicit offense if the offender's behavior directly threatens or harms an identifiable person or individual, that there's evidence of behaviors that pose a direct risk to public safety. When an offender is arrested on the commissioner's warrant for absconding, a documented pattern of risk-related behaviors where previous interventions have failed to mitigate the risk, and a documented pattern of history of behaviors that continue after the exhaustion of lower level sanctions have failed to gain the offender's compliance. Those last two are really tied to the Rule 74 and the changes that were made under the community supervision for law. We can move Monica to the next slide.
So Dale, I have a question. This significant violation, just to find it, is that definition within your directives at all?
Yes.
Okay, so you've included that within your directives, or it was already there?
This is a policy. So we have a case staffing process, and only a central level review can approve an interrupt of a furlough. And how we had it set up to improve consistency. We have a kind of a chart now that, based on risk level and the number of significant violations the offender previously had, determines what the interrupt will be. So it's no more, it's much more concrete what it's going to be. There's some leeway that we can have aggravating or mitigating factors, but it's much more defined, and the need for the significant violation in order to go and to begin that case staffing process and to have the offender lodged is laid out right here. So it really does forces the department to work with offenders in the community to a much greater extent.
And that is all in a new directive that we put out. We revised our directive on like non-compliant behavior for people in the field, and it goes through all of the things that Dale mentioned, all the technical violations, all the risk level sanctions, defines what it is, talks about how those interrupts would work. That was another really big part of what we had to do in terms of implementation, was writing it all in the directives.
Yeah, thank you.
So I think we're off to parole now. Unless there's any other questions.
Are there any other questions on
Oh.
this, the furlough piece?
Oh, I see.
Teresa had a question.
I don't have my participant list up, so who had the,
Teresa.
Teresa?
Yes, thank you. Thank you. Just related to what you were just speaking of, I'm just curious if CSG and the whole data component is will be collecting information about variability by region of implementation of these directives and the changes in policy, so that we can see perhaps training needs that might be needed. And also, I'm presuming, but I learned that presuming is not a good thing, that we're also collecting data by various demographics and race, et cetera.
Yep. So I can certainly address that. There's a pretty comprehensive data sheet that we're working with the Council of State Governments on, and it covers a bunch of different areas. The first is generally just sort of like the raw count of numbers. Who's on what type of supervision? And in those counts, we are going to be looking at demographic information. Then we'll be looking at sort of what we're going to call transition or status changes. Who comes into a correctional facility from probation or parole? Who is released? How are they released? And then we'll start to talk about the violations. And so a lot of that is going to be unfolding and coming more forward, I think, towards the working group. And I know that Council of State Governments is planning on presenting that more thoroughly to people in the coming months.
Any other questions before we move on? I don't have the participant list up, so just raise your regular hand.
Okay, so parole strategies now, and one thing I do want to point out is the parole board has been a tremendous partner with us. Chairman George and Director Ainsworth have been really good partners in helping the department and the parole board work together to really implement justice reinvestment. I cannot say enough positive things about them. So some of our strategies for around parole is that we revised our parole directives and recommendations. You know, it always used to be historically that parole was an earned legal status. So someone had to earn to get parole. We've kind of changed that with how we're strategizing now. When someone is getting ready for release from our facilities, if we're going to release them on furlough, we will be recommending a positive parole. That's our new standard coming out of the facility. And the parole board has been receptive, and the parole board has been increasing the number of people paroled directly from the facility, which is great. We've integrated presumptive parole process. Presumptive parole is not a status, it's really a process on how to get paroled. I think we've had 6 cases go through right now, 4 have been approved and 2 have been denied based on that process for parole. Understanding that it's only for the non-listed population right now, and the way that justice reinvestment is kind of setting it up is in 2 years, or actually a year and a half now, listed offenders will be eligible for presumptive parole. So we kind of graduated into it by using the less concerning population to kind of make sure that we have our processes down and that it's working well before we go to the population that's more concerning and that could present more of a risk to the community. We established new timelines for reviewing cases for parole. We've established a process for when the DOC and the department does not think someone is eligible for parole. And the GRI legislation, it's pretty specific when the department can and can't refute someone's parole recommendation. It really comes down to if we're not going to release someone on furlough, we're not going to recommend for a parole recommendation. We revised the recommendation criteria to increase the use of parole as our preferred supervision status coming out of the facility. And we're doing that right now. As I said earlier, our furlough cases are as low as they've ever been since I've been in the department, which is great. And more has been shifted to parole. Having individuals on parole gives a lot more due process rights to the offenders, and it takes some onus off the department and shifts it to the parole board to make those violation determinations. We revised our contact standards, creating, we said this before, creating one standard. So someone on parole and someone on furlough, they're at the same supervision requirements and status that we have. The only difference is the conditions that were applied. And one thing to understand that this is an example of how the parole board has been really great partners with us, is we went through a huge process and working with David on some level to change our conditions of furlough supervision. And then we introduced those to the parole board and worked with the parole board to have them work with their conditions to better align their conditions of supervision with our conditions of supervision, which I think is a great example of collaboration between the two entities. We've also continued, as I said, with the collaboration with the parole board, and I think that relationship is very strong now. And I think we have both agencies have really embraced justice reinvestment, and we're really kind of pushing forward with that to really help implement justice reinvestment and the really the spirit behind justice reinvestment.
Well, I'll give Dale some breathing room and take over for a few slides here, and talk a little bit about earned time. You'll see I made a common error that I think is going to happen a lot in the next few months is I left the word good on the slide. As we all know, S18, which just passed in April, changed the name of the program to Earned Time. And we're still finding instances of it someplace. So I apologize for that. But as you all know, earned time was a very significant strategy that was adopted actually prior to Act 148, modified in Act 148, and further modified this year in S18 Act 12. Essentially, the earned time program was adopted by rule. So on January 1st of this year, the department started awarding earned time to all eligible incarcerated people. And we were able to implement that again, based on the emergency rule. We also filed a permanent rule at the same time. We held many hearings. This happened late last fall in the November timeframe. And as you all know, based on our rule filing, there was a lot of outreach from victims, and that really did lead to the introduction and passage of the act that modified earned time. So now that there's a group of people who, if they were convicted of these disqualifying crimes that are listed in the new law, they are not eligible to earn time after it's April 26th. That's when the governor signed the law. Just so you know, that impacted about 202 people. So there were people who were able to earn time from January 1st to April 26th that are no longer able to earn time. So we have finished with the rulemaking process. We did have to modify our final adopted rule once S18 was passed. We have gone to LCAR. LCAR has approved the rule, and the final rule will be effective on June 12th. At this time, what the department is doing is operating off of the new law. And so that's our process until June 12th comes. There's a couple other things in the rule that we'll be able to do once that's passed. I can tell you that, generally in those months, January through April, the department was awarding time to about 1,000 people, because it includes incarcerated people and people who are in the community on a furlough status. So it was a pretty big endeavor. We did need to hire additional staff in our sentence comp unit in order to manage the process. And we've made some pretty significant efforts in our database to try and automate it as much as possible so that it's not as much of a manual process. The next thing I wanted to talk about, if anyone doesn't have any questions about earned time, is what we're going to be doing with the sub-award funding, or what we plan to do with the subaward funding. So with phase 2, Vermont is eligible for subaward funding. It comes from the Bureau of Justice Administration to the Council of State Governments, and the Council of State Governments subawards the funding to us. And so we've worked really very extensively with our team at the Council of State Governments to determine what might be the best use of these subaward funds in order to bolster and support the other strategies that were adopted in Act 148 and further adopted in some bills this year. So I'll just give you an overview of what we plan to do. I do want to let you know that the Bureau of Justice Administration has not yet awarded these funds to CSG. And we actually don't know, I just talked to them, unless David, you have some magical information I'm not aware of yet, that when we're going to get the award. We know that they've received the application, the policy piece has been approved, and now it's just sort of in that bureaucratic place where somebody needs to press a button. So once that happens, and CSG will get the award and give us a notice of that, then there will be a lot of activity that needs to take place. Of course, we need to go through the process in the state of accepting the award and going through the joint fiscal process there. We have a fair amount of contracting that we need to go through. But in the end, what we'll be doing with the money is sort of in these 3 main buckets. There's almost $300,000 here for various types of trainings, and it's spread across a number of different contractors. And really, they're all designed to reinforce a lot of the philosophies and goals that Dale went through so beautifully around how to use evidence-based and risk assessments, how to use screening tools to inform decisions, how to understand the model that we use in the criminal justice system of risk, needs, and responsivity, and also how to really collaborate and share information across entities that are really working with those people who are criminally justice involved. And a big focus of this will be on those mental health and behavioral health providers. So a lot of the workshops and trainings that we've designed are going to incorporate a lot of our partners within the Agency of Human Services, but also our other community partners who have a role to play in successful reentry and supervision. There is another about $120,000 that we're going to put into our database. We have some very interesting and exciting enhancements that we're planning on implementing over the course of probably the next 6 months or whenever we get the funds. And this will really benefit not only the Department of Corrections, but the parole board as well. The parole board uses our offender management system for their own purposes, so that their data will also be enhanced by this. But this general enhancements are designed for us to keep better track of some of the information that you've all requested many times, a lot of it having to do with technical violations and returns. But also help our staff really manage cases much better and understand where their cases are in the system, and have really easy access to the information that we store in the system. But it's not as easy for them to get, and it's not as easy as for us to get out. Then there's another small amount of money just for administrative supplies. The parole board needs some monitors. We need some supplies in order to implement some of the strategies that we've invested in to support some of the database enhancements. I see Senator Lyons has a hand raised. I don't know if it's about this.
Yes, go ahead. I don't have the participant list again, folks, so just raise your physical hand would be a help. When I share the screens, it's hard to have the participant list. So Jenny?
And I'm sure that you have talked about this internally with AHS, but as you're talking about shared resources within AHS, and obviously there are mental health as well as substance use disorder needs and counseling needs. There's also housing issues and coordination of those housing opportunities, working with our DAs, our SSAs, and it goes on and on. So this is a very discrete program, but it could have significant implications for those other folks.
Sure.
And as I'm listening to you, I'm thinking, do we have, for example, a central housing coordinating system so that the Howard Center isn't stuck with trying to find a place? It's not stuck, it's doing another additional work on our behalf. So any systems coordination that you're thinking about, and then additionally, sort of the mental health services, who will be overseeing those mental health services or the substance use disorder services, and how is that all going to be coordinated?
Sure. Well, I can tell you what we're going to start with, and
good.
let you know that we've let you know that we have had a lot of sort of introductory meetings. For instance, I myself and another colleague and I met with the executive directors of the designated agencies to first give them an overview, really, of justice reinvestment, because a lot of them hadn't really heard the details of it. And then describe to them, what the goals of this this particular subaward funding is designed to address. And I just want to clarify that as well with you. CSG was very clear, and David made these points very well. And so if I get them wrong, David, certainly chime in here, is that one of the things that they found was that there was not really great information sharing between, we'll say the Department of Corrections, designated agencies, preferred providers, in order to coordinate services for people who are under corrections supervision and have mental health, behavioral health, or all three of those things. So this pot of funding is specifically designed to address that. And I think it is a start to sort of imagining what could be possible and maybe getting to the conversations that you've brought up, but it is not designed to do what you have just raised.
Okay, so will we
Senator-
be seeing, I'm sorry, go ahead,
Senator,
Commissioner.
if I can just chime in, this is really part of what I described earlier around the chronic care piece. Secretary Smith has designated Deputy Secretary Samuelson to lead up, and the commissioner, this is at the commissioner level right now, with some other participants in the conversation.
Okay.
We are focused on a particular project right now, but the working group is known as Justice Reinvestment within AHS. So that process is starting. Specifically talking about housing, we're not down to that conversation yet, but the secretary has directed that the issues around what we face on reincarceration is not just DOC's issue. That it's a mental health issue. It's a substance use disorder issue. And so we're also coordinating with ADAP on ADAP beds. We have a partnership starting with them around if we need an ADAP bed for an individual because of a substance use disorder issue. We've started those conversations. So I don't know if that helps or not.
Well, no, it does help a great deal. But just my concern is that the work begins, it goes on. The work that's going on is absolutely terrific. There's no question about it. But as it's going forward, it would seem to me that what you have said, having the secretary involved and the coordination within the AHS between and among all of the various departments and subdepartments, divisions, all of that is going to be critical to have this run smoothly. We have such a difficult time now covering all the needs that we are seeing that I would hate to see it become a competitive, I was going to say battle, but it's never a battle, but become too competitive between different needs within the state and within the agency. So I guess it'll be our responsibility in our committees of jurisdiction to bring folks in to fully understand how that systemic, how the systemic change is going on and what's happening in our individual communities, towns, DAs, SSAs. Oh, this is the beginning of a huge, huge shift, but so thank you. Sounds like it's happening.
Thank you, Senator.
If I may add just one comment, Representative Emmons.
Sure, go ahead, David, and if you could introduce yourself for the record, because we do have some new members on our committee that may not know you.
Certainly, for the record, my name is David Demore. I'm with the Council of State Governments Justice Center, where I'm a senior advisor. And I just wanted to respond, Senator Lyons, about what you were describing in terms of the long-term needs and AHS and covering all those things. One of the pieces of the training that Monica is talking about is specifically designed to be an organizational and leadership changing for, organizational and leadership change training for all of the AHS departments to really look at and focus on these issues so that it does not become a competition, but does become a collaborative response to this very significant set of needs that these individuals have. So I just wanted to mention that.
Oh, thank you very much. That's extremely helpful. And likewise, it'll be helpful for us in the legislature to see it as a collaborative process so that everyone receives the support services that they need.
And Jenny, I think your concern is well-founded because in the past, this was done before, though not formally, with the structure that we're working with now. But I remember way back 15 years ago, maybe, when Patrick Flood was with the agency, and we were really concerned about folks that were incarcerated with mental health issues. And he put together within the Agency of Human Services an intra-agency group to really work with DOC when someone was due to re-enter the community with mental health issues. And where all the players, the Department of Mental Health, DALE, ADAP, DCF, all came together and worked on this person's case to really pool their resources and pool what was available within their own department or their own world that could support the person re-entering the community. And that was very, very effective for a few years. And then he moved on to something else and it fell apart. So the key is to really keep this, if it's successful, number one, to stop the battle in terms of protecting your budget, because that's what some of this is all about. Put it on DOC's nickel instead of our own. And number two, that you have the continued leadership in place for it to continue to work. So I really appreciate your words, Jenny, because if we can systemically change how we approach it within the agency, it will carry through, is the hope.
Well, it does need to be institutionalized. There's no question about it. And it is a collaborative process. It can't be, right now, it must be DOC, but in the future, it's going to have to be everyone working together. Yeah.
Mm-hmm.
Thank you for that historical information. Historic or historical?
Well,
History.
I'm probably more historical than anything.
I will say that as we have talked to some of the designated agencies and some preferred providers and then our other partners, within the Agency of Human Services, not at the commissioner level because the commissioner's handling that, but at the, a lot of people remember this work that you referenced, Representative Emmons. And I will say that there are some, there's a lot of interest. People want to do it. They're very interested in justice reinvestment and want to support it, and also are wondering how will it be different this time. And I think the how will it be different is really the fact that we're addressing it on these different levels, sort of at the leadership level, at the real like on the ground level, getting those people involved, and trying to coordinate it is really going to be the most important piece. So that's what I see, and that's kind of what I'm hearing. There's a lot of great work that's happening, and it's just needing to bring it all together. And I will say that, as we get into the more specifics of the contracts, so right now these are all proposals. We don't actually have contracts with people. We do have people lined up. We have the work scoped out, and once these contracts are executed, we would be happy to talk to you more about what the specific details are. If you're interested in hearing that level of detail, I just didn't feel it was necessary for this particular presentation. So if there are no more questions on the sub-award funding, then we have just this one last slide. I think we've talked about a lot of these things already. Just to let you know, that there are some ongoing efforts. As you know, there was some new legislation that was passed this year, and the department is implementing those. We've talked about our DOC-led initiatives, and we talked about data monitoring, but I know, Dale, maybe you wanted to get into some specifics on some of the things on this slide, maybe cover the areas that you haven't addressed already in the previous points or slides that you've got.
Yeah, thanks, Monica. So some of the stuff has been brought up. Act 14 was passed, and we have a pilot project starting up. We have our first meeting tomorrow. This was something that was really pushed by CSG and by David Demore about having conditions of probation set based on risk and needs of the offender to better match what is needed to help the offender be successful in life and supervision. So that's starting up tomorrow with the initial project. Act 24s are on midpoint probation review and termination. This was kind of, took a few turns over the course of the last two sessions. It started out with credit. It was kind of a recommendation of the department that our largest supervision population is probation, and justice reinvestment hasn't really tackled it until this time. And Act 24 addresses that with the expansion of midpoint review, makes it more presumptive, put some criteria on it when the department shall recommend a discharge. The purpose is that if someone has completed their risk reduction services, keeping someone under supervision on probation is counterproductive. Kind of moves people through the system that need to be moved through the system as well. Monica did touch about the change of earn time. The next couple are pretty exciting for the department. One is the Focus Deterrent Project. Commissioner Baker, when he was Chief Baker of the Rutland Police Department, kind of worked with David Kennedy from John Jay College to create a new model of community involvement with policing. This is kind of an extension of that. It really focuses on intimate partner violence. Working with John Jay College, we have a contract with John Jay College and David Kennedy, kind of spreading out of dealing with violence and gun violence. We're trying to make this more of a community response to both supervision and support for individuals who have been convicted of intimate partner violence. Intimate partner violence is one of the more difficult and dangerous cases to supervise and to treat and to deal with, because there's not really a huge plethora of evidence what really works to help maintain this population. This is very exciting. We have 2 pilot sites located in Rutland and in St. Johnsbury, where we've been meeting with other community providers, we've been meeting with law enforcement, state's attorneys. It's really a wraparound model to help support the offender, help support the victim, and help really find a successful mechanism to really monitor and supervise this population. The next is our complex community project that we have going on. The Commissioner kind of touched on this earlier. This is very very interesting right now. So the concept of this really originated when the discussion was around, should we put a clinician directly under our probation and parole offices? Commissioner Baker has been banging the drums that we have this very complicated population that we supervises, and really the supports out there aren't really matching the need for the complexity of some of our cases. So how we started with this is we reached out to our Burlington office because they have the most resources right now in the communities, and we asked the probation officers, who are the most taxing people you have on your caseload? Who's using all your time, all your resources? And we get a caseload or a population of offenders. And what we're going to be doing is we're going to be designing an intervention model basically from the ground up. So the population that we have, I think Commissioner Baker touched on it, they're not necessarily the most highest risk, but some of the themes with this population is lots and lots of trauma, a lot of antisocial personality disorders. They have relationship issues. They can't maintain jobs. All of our interventions kind of up to date that have been applied to them haven't really worked. We're working with Vermont Forensics and we're working with UVM to help us kind of analyze the information. We've done some assessments, and we're really looking at a model that's based on the intervention first and then supervision second to really address this complicated case. You know, and this kind of ties into the next one that Commissioner Baker was talking about with the AHS Justice Reinvestment Team. Within that, there is something called the VCCI, which is Vermont Chronic Care Initiative. And doing a quick comparison with the population that we pulled out of the project, 29 out of 30 were involved with this chronic care. So we're dealing with the same population. And the concept of this is really to make it more of an agency approach. The VCCI really is more focused on medical and treatment. But I think there's a lot of synergy that can happen now that we're having the larger AHS umbrella looking at the services that we need as well. And of course, we have ongoing reports with CSG on implementation, data monitoring, as Monica was talking about, lots and lots of data monitoring, and then still waiting for the sub-award planning. And I see Senator Lyons has her hand up.
Jenny?
Well, you brought up the chronic care initiative, so I couldn't let that go by. So while you're talking about chronic care needs and healthcare needs, one of my ongoing concerns is how healthcare has been provided to those who are incarcerated or on parole and so on, and eligibility for our state-funded and federally funded programs, and how is that being addressed within the AHS? It's not something I think DOC can do or Justice Reinvestment can do independent of our various healthcare programs. And so you brought up the chronic care initiative, and I am just wondering how that you're talking about healthcare within this program.
So Dale, I can take that if that's okay.
Absolutely.
Senator, this is part of the conversation at the commissioner's level. And just yesterday we're meeting every Wednesday about justice reinvestment at that level. There's a subcommittee that's starting to work now. And this is part of the 1115 waiver conversation and negotiations with the feds for the waiver on the 1115. Our goal, and I don't want to give you a time frame, but our goal is in marrying together chronic medical care and chronic care support from our side of the issue, from corrections. Our goal is to try to get healthcare coverage 2 individuals who are preparing to be returning to the community at an earlier date, so we can then get those individuals together ahead of time with a healthcare provider, be it a mental health provider or a medical provider, while they're still in the facility, either through telemed or through getting them out to meet the provider, in order to build a relationship between the incarcerated individual and the provider before they get out. Because what we're seeing is folks get out, normally they're carrying healthcare, but they haven't developed a relationship with the provider. And a lot of times it falls apart. So that was a big part of our conversations yesterday, and we're starting to explore that. And that's what that sub-working group's one of the things that the sub-working group's going to work on in order to better enhance the ability to build that relationship. So once they're out, they have that relationship, and it's more likely to be successful than that.
So this is something that I welcome. I think it's the right conversation to have. And I worked with the previous commissioner in talking about how to make something like this happen, not just for those potentially being released fairly soon, but also those who are incarcerated, to establish a relationship external to the building. So, but it may require a federal, I call it federal forgiveness, and I'm glad, I know it's going through the 1115 consideration. As you're looking at this and knowing that some of the folks who are incarcerated will be released, will be in different places in our state, so establishing a relationship with someone in the Northeast Kingdom, it's going to have to be probably by, unless they're up there, depending on where they are, it's their home primary care. There are a lot of issues that are raised when we start talking about this. I know Senator Hooker and I are very concerned about primary care generally, and but I'm very happy to see that this is the direction that you're going. The more we can expand it, the better.
It's amazing the conversations we're having, Senator, where we find out that what they're doing to screen for chronic care initiative has this, it may not be the same screening tool, but it's the same concept. And so we don't, we don't screen for those issues. And it really should be part of the intervention strategy. So it's amazing what we're finding out by having these conversations where we can create. And the next thing we're going to do is take case studies, map them out on how we're going to marry this stuff together, and do I'm talking emergency management stuff now, reverting to my former life, tabletop it out to see how it flows through the system, to identify where we need to make sure we got an eye out for where it can get disrupted or derailed.
It would be great to ask for additional funding from the federal government while we're doing this. We'll continue to expand our Medicaid waiver, but we don't expand the resources that we have. So I would encourage that push big time.
I will bring it back. That's really starting to get out of my comfort zone.
I am sure.
The 1115, I just learned about that now. So if I get too far into this, I'm going to be way out of my comfort.
Oh, some of it's been, we want more money all the time, but we deserve it for the work that's going on. I think it needs to be rewarded with increased resources.
This chronic care initiative that we're working on, I believe, could be a real game changer. Because it's really forcing everybody in AHS to wrap around an individual cases that Dal was talking about earlier. I believe if we can get this off the ground, it's going to be a game changer.
It shouldn't matter who the individual is.
Correct. Everybody deserves that care.
Yeah.
We have another question, Cheryl?
Just to reinforce what Senator Lyons had said about, and someone mentioned it earlier, that, reentry preparation should begin the day somebody is incarcerated. So to make sure that we can do this chronic care wraparound from the beginning, because my concern is that those people who are incarcerated are not getting the help that they need, as much help as they need while they're incarcerated, not just while they're preparing for reentry. But that, I think you're getting to, and hoping that, that's going to be the expansion of this chronic care program.
And again, our part-time medical director, Dr. Strenio, is part of the driving force behind this. And our healthcare provider, Vital Core, is part of the conversations. So we are starting to bridge that, Senator, and to your point.
Anything?
Yeah.
Else, Dick?
Quick question.
Mhm.
Somehow I thought as part of Justice Reinvestment 1, or even before that, we had put into statute the requirement that case plans be done. This is like 15 years ago. That case plans be done on as soon as possible on the entrance of somebody into prison or jail. And now we're talking today like it's something new, and I'm just curious what happened.
As far as the individuals coming into our correctional facilities, case plans do get created at the beginning of their sentence. What I was talking about is we've modified our case plans. We've worked with our database system, our OM offender management system, to incorporate things. We've modified it to a degree. And then we've also taken, for the furlough population, it really hasn't changed. It's really with that probation section that we really modified it to be more based on the conditions of supervision. We try to enforce our case plans around risk and needs based on the risk assessments. And someone that scores moderate or high on one of our risk assessments, we address it with our case plans. With probation, it didn't work that well, that we tried to make someone do mental health counseling, for example, but their conditions of probation did not have mental health counseling. So we're at this situation where there is tension trying to have the probationer address the mental health needs, which he very much needs to do, but we didn't have the authority to go around doing it. That really ties in to Act 14 in that felony probation project, where if we can get the right conditions to best address the offender and get those set at the beginning of probation based on risk and needs assessments, and that will really feed in to the changes that we've done with our case plans and our supervision contracts. There's a lot of moving parts with justice reinvestment, and some are moving faster than others. Right now, we get the pilot project going. This is really a big push from CSG and David Demore, and the department really agrees with it, because we're trying to manage cases on our end, the probation officers, and they don't really have the conditions to best address the needs of the offender. So hopefully that pilot project is starting tomorrow, and that should really hopefully be successful and something we can bring back. We do have to report out on that, I believe, in December of 2022. So we're just starting that tomorrow, and hopefully we'll get good outcomes with that. Then that's something that probably will be incorporated because it's going to make sense.
Thank you.
Yeah.
So I have a question just for clarifying on your last page, Dale, the bullets.
Yeah.
Where you have the complex community case pilot project, which the initiative of that was putting a clinician in your field office, your PMP office. And you're going to do that in the Chittenden office. Is that connected to the chronic care initiative that's in the Agency of Human Services wide team meetings on shared cases? Are they connected or not?
No, not yet is probably the right answer. So we have been working on this project for a couple of months now, the complex community case pilot project, and we're really still building at what it's going to look like. We're trying to get the right intervention models, find supervision strategies, find trainings for the two POs that we have assigned to it, and the community corrections officer assigned to it. And as we're looking at how to build the supervision and intervention model around it, VCCI came in from two different directions. One is from our director of mental health, who works with them already on other cases, and then through the AHS and to our Deputy Secretary Samuelson has been working on. So we're looking how we can marry that in with our project that we have going on, our pilot project in Burlington, because really the VCCI is going to focus a lot on the medical side, and kind of the hope is at some point the department will be supervising and managing the criminogenic and the risk of the offender, while we'll have other services that will help work with the mental health, or not the mental health, but the medical and MAT and things of that nature. We're looking at the intervention with a provider to come in. We'll probably have to contract this out through the RFP process, because what we want this contractor, we still haven't figured out what the clinician's going to do, but one thing we know it's going to do is really improve the skill base and the knowledge of our probation officers, because we're not trained to deal with this population. We'll add, kind of clinical assistance to how we manage cases to help identify issues, and also help identify plans and treatment plans for this population. So it's really bringing in someone that has that level of knowledge that we don't really have at the PO at the line level. And part of this is really to respond that sometimes not the community providers aren't really there to meet this need yet. We're dealing with mental health, we're dealing with substance abuse, trauma issues, all the social economic issues that come with some of our population, and we're dealing with criminal issues. So it's like this huge complex case that we're dealing with, that we're trying to find an effective strategy to deal with our most complex cases. And as I said before, I think we had 30 people identified, and I think 29 were already working with VCCI. So now it's how do we coordinate that better, as what the commissioner was saying, how do we coordinate it to have the case manager from VCCI part of our supervision model, and how can our POs be part of the treatment model and really integrate supervision, treatment, medical, on a more holistic approach, which is really what the AHS is. It's entire individual, and all the departments kind of have their own silos, and we're trying to weave all the silos together to really look at how we provide this supervision to really to the best outcomes with a really difficult population. Now, not everyone needs that high level of need, but we do have a chunk of our population that we do, and we can also learn for our, the population that's a tier down or 2 tiers down, lessons that we're learning from this group that we can transform over to that population. So we're trying to really increase our level of dealing with this population.
That helps. Thank you. Any other questions here before we begin to wrap this up? Anything else? I'm not seeing anything, so it looks like we're finishing up here with DOC. I know at some point Senator Sears put out about really looking into the issue of congregate housing versus the contracts that were approved this last time around. I don't know if we want to get into that now or set that up for another item on our agenda for our next meeting. I'll just put that out there for the committee. See, Dick?
Well, I'm fine with it being at our next meeting. Hopefully David Diamora can join us at our next meeting, whenever that might be, and we can have a discussion about how, I think that the decision's already been made, and but I do want to fully understand how it's going to work. And particularly, once we lose many of these programs, they'll be hard to recover. So, but.
So I think that would be a good hour conversation, I believe.
Yeah, I would think so. Yeah.
So let's see if we can plan on that for our next meeting for folks and give DOC and David a heads up. We don't know when that next meeting will be, probably sometime in July. But I'll just give you a heads up.
Alice?
Yes,
And
sure.
I certainly hope, and again, I've spoken with Commissioner Baker about, the housing, the congregate housing versus the scattered housing approach. And my concern is that intersect between, the need and the availability of units. And we're seeing that every day, that, units are scarce, especially certainly in the Rutland area. And so I hope that we can have someone speak to that, the availability of units for the need that will occur, whether it's from people who are being released from the facilities or people who are in hotels now being housed by the state.
Right, so let's put that, this is a good transition to the next part of our agenda for today. I don't know if people want to take a break, a lunch break to continue this, or just finish everything up. Where are people? Because we want to spend some time to talk about what are some of the issues we want to deal with within our committee over the next few months. And one, of course, is the congregate versus the scattered housing would be one. Do we want to do that, figuring out issues we want to talk about right now? Do we want to take a break, take a lunch break, or just keep working?
Well, we're done at 1:30 in any event, right?
That's
Let's
the
keep
goal.
working.
Let's keep working. It's fine with me.
We're
So we
used to
have,
working hard. We may as well keep it up.
yeah, right. And finish up our Zoom for the day. So for DOC, you can listen in on where we're headed here in terms of thoughts from the committee members, in terms of what agenda items we'd like to see over our next few meetings. We're pretty clear. One would be the congregate housing issue and the contracts that went out, and connecting that with CJ, with the council, state governments. The other issue that we should be spending time on, of course, is the expungement issue. How to look through, to simplify and review the process. So we need that definitely, particularly for next meeting. And I've asked both our judiciary chairs to work with Peggy to work through our witnesses for that. One of the requests was also getting the chair of the Sentencing Commission to come in. And then another issue was trying to think where it was.
The issue on housing rose up today during a discussion about for juveniles, but also for youthful offenders. And what's available for 18 and 19-year-olds, as well as those that are adjudicated youthful offender. That was something that was in the 2019 report that I don't think we've dealt with yet, we being administration.
Do you want to include anything on the Beckett?
Well, the Beckett thing is I keep hearing emails. I know you have seen them too. Other members of this committee probably seen those emails from the people in Newbury who are not happy about having a Beckett. And I don't know if Beckett's if it's really gonna happen.
I think we need to hear about the juvenile justice plans that we heard some testimony in our committee at the end of the session, and it is I think you raised an important note, Senator, about is it going to happen or is it not going to happen? I think there are significant barriers in place, and essentially we heard there is no plan B, and we need to hear about that.
Okay.
Can I
Others?
raise another issue? It's not the Beckett issue, it's not related, but it is a result of listening today. It would be good at some point when there's something to report on the 1115 waiver and how the coordinated activity is going on within AHS on justice reinvestment and healthcare.
Mhm.
And something that hasn't come up yet, I don't think, but we certainly were made aware of it last night at a meeting, and that's the Women's Correctional Facility. Still in an emergent, an emergent need to discuss that and to figure out what's going to happen.
In what
with that
way,
facility.
Cheryl?
I'm sorry.
In what way? What would-
To see what can be done. We've had the complaints about the Women's Correctional Facility for a long time, as far as the condition of the facility and the fact that there's no room for programming and et cetera. And I think that, I certainly need to be more informed about what's being done to ameliorate those problems.
So you're not talking about the movement we've been making to replace the facility. You're talking about the current facility and the maintenance of the current facility.
Correct. And what's being done in the interim before a new facility is available. And I know we talked somewhat about this last night, and the commissioner indicated that there will be a position of women and families, director of women and families, that will be reinstituted. So that's a step in the right direction.
Other issues that we want to discuss? Is it too soon? Spend more time at our next meeting?
Well, I think the expungement issue and versus sealing is going to take a long time. So that seems like multiple meetings, and if we only have 6, that might be enough.
So according to Bryn, we got to really spend time on the expungement up front. And Bryn, there was another one too. There was 2 of them that we needed to.
Yeah, there was the transports issue.
Transports, that was the one I was trying to find. The transport, okay.
There is the auditor was supposed to do a report on the use of transports during the pandemic by state paid deputies and what happened to that. And the auditor wasn't able to do it. We put money in for a special contract for the auditor in H315, which was the second appropriations bill, the one in between the real appropriations bill and the budget adjustment bill. So I'm hopeful that I think it would be helpful to have the audit before we take that issue up.
So has the audit been done? Has the auditor done that?
Hopefully it's ongoing. I mean,
So he could give us a check-in? We could do a check-in with him?
well, I would hope so.
Okay.
It may be later in in August or September before he's done with that. But we need to, the question is, with all the video arraignments and other things, do we really need 25 state transport deputies out of each sheriff's department? That's the real question. And is there a better way to do it? That was, it started in the 70s when we took the county jails away from the counties.
Mm-hmm.
And times have changed dramatically.
But it's also the bill is also, the study is also to look at not just transporting DOC folks, but it's also transporting
Well,
folks
you
in
have a
mental health.
strange situation where AHS pays more for certain groups of people who are transported. DCF pays more. The mental health patients are more
Mhm.
than DCF, than the prisoner transports. And then you have BGS sheriff's hours, which pay more. So it's all these different costs. And I know that one of the problems that DCF had was workers being required to sit with kids or kids being in police stations because they couldn't arrange a transport. Now, Sheriff Mark Andrew, right, in Windham County is in the process of a appointment. He's trying to work out a contract with DCF to provide transport for DCF kids. So they're not sitting either in a hotel or in a police station or with social workers.
Maybe it would be good just to get that full overview of how transport happens now and the complexity of both the types and issues and costs.
Mhm.
I mean,
Yeah.
I think, because I agree, we haven't looked at this in a long time. I remember when the discussion was all about the securing the person being transported and juvenile security, and it
Yeah.
is, it gets very tangled, but it would be great just to have that overview.
So we heard a lot about that. You're right, Jenny. A few years back, and I don't know I don't remember what the outcome was,
Yeah.
or if there was never an outcome to our discussions.
I don't think
It
there
just
was
kind of
that.
just fell off the edge of the table because it did. It all boiled down. I think the discussions at that time all boiled down to how much are we going to pay sheriffs and others to transport people. I think it just fell off the edge of the table.
In other discussions, there's also the possibility of putting the transport for prisoners under the judiciary, so that they would be responsible for it, because we heard complaints from sheriffs that transport deputies are sitting for 5 hours waiting for the case. They have to get there at 8:30 a.m. from wherever, say it's Burlington to Bennington, and then they sit there waiting to get called, and it might be noontime before the case gets called, because they take all the people that have private attorneys arraignment, and they take others, and then they finally go to the people that are transported. So it can run into a 10, 12-hour day just round the trip.
So to do a real overview of this, who should we have in besides sheriffs? I mean, we can have the sheriffs in.
We should have the judiciary, we should have the auditor, and I think we should really DCF and mental health.
Yeah.
And BGS, because they're all got contracts with the sheriffs at differing rates.
That's one thing for a long conversation.
Yeah.
Well, the study was going to be done by a different group, and the House conferees on the budget ended up settling on Justice Oversight.
On us. Okay.
We-
Other issues. Right now, we've got DOC congregate housing versus the scattered. We've got housing for 18, 19-year-olds, the whole juvenile justice thing with Beckett. And if no Beckett, what's Plan B? The 1115 waiver and coordinating DOC and healthcare. Current maintenance of the women's facility. Expungement, that whole issue, doing an overview first and then getting into a deeper dive of that, and then the transport issue. That's what we've got so far for our next few meetings. So we'll do expungement next meeting and maybe start the transport issue,
Yeah, we got a deadline on that.
those two things. Maybe we could also schedule in a quick update from BGS on the maintenance of the women's facility. That shouldn't take too long, I wouldn't think. Does that make sense for folks? So Peggy and I will work on that, as maybe Bryn. And then if Maxine and Dick can also work on the expungement issue with the respective folks. And then I'm assuming there'd be a doodle poll that will be sent out for our
Yep.
next meeting.
Do you have any particular days that you want me to put on, or?
Oh,
Not June 22nd and 23rd.
yeah, right. Oh,
Do you
well,
want,
we're kind of looking at July, aren't we? We don't want to do another one at the end of June, do we? No. So what, the middle? I'm open to any suggestions.
do you want to keep it to Thursdays to keep it a little simple?
Does that work for folks?
July 8th? Or, but that's a tough week because people are on vacation probably, right?
I'll be gone that week.
July 15th?
Could do that.
That works.
That works.
July 15th, 9 to 1:30?
At least
I
1:30.
may not be around, but I will try and change my schedule.
Do Thursdays work for folks?
Thursday's fine if it's Zoom.
Yeah.
9 o'clock is fine if it's Zoom.
Right.
Yeah.
9 o'clock is not fine if you're driving up there.
Right, so
And hopefully by July 15th, we'll know more.
assuming it's Zoom.
Yeah.
Right.
Well, I
Yeah.
don't think we can, I doubt, I mean, I think we can set it up as a Zoom meeting for that
Yeah.
date. And if people want to be in Montpelier, they can.
Yeah.
Those of us who've got to drive over 2 hours could be excused to be Zoomed.
Mhm.
All right, so July 15th, 9 to 1:30, and then we'll probably know more about in person for the August meeting.
Yeah,
Does that sound good? All right.
Sounds good.
I'm fine with going 9:30 to 2 or something. Actually, I got to be back by, so on Thursdays, I have to be back by 4:30.
Well, let's figure the July meeting on
Yeah.
Thursday, and then we can adjust come August.
Yeah.
If we're doing that in person. Come August
That was the 15th in July, Alice.
15th
Yep.
in July.
I'll send a calendar invite so you guys get it on your calendar.
You know, we could always meet at a correctional facility.
Good. Once the restrictions are lifted.
Mhm.
I don't know. So anything else before we finish up? I don't see anything. So we're done our work today. Thank you all. It was good seeing you.